Wonderful to have everybody back again, and we'll be starting our last and final session. 2 quick notes before we do. The first is for folks who want to stay afterwards, we do have the room and we'll have our typical refreshments. It's a really nice time to mingle and meet other people or ask questions of any of the panelists if you want. Second is, as I mentioned at the very beginning, this is our 3rd year doing this, and each time we try something a little bit new to see what's the most useful for the people that are attending, either in person and online. And so in a few days, we'll be sending out a thank you and an evaluation form. And I really, we read all of them. So I would love feedback. We would love feedback on not just the sessions, but things that you'd love to see in the future. We've talked, for example, about discussion groups or more participatory things from the audience, but we're not sure if people feel comfortable sharing things about their own organizations. We've talked about keynote speakers. We've talked about a full day format. We've talked about separate staggered sessions. So this is really for you and would love to get your feedback. So please don't bypass that link when you get it in a few days. One of my colleagues, Ross, will be closing at the end of this, but for the moment, I'm delighted to pass the baton to 2 of my lovely colleagues, partners from our Denver office. We have Matt Johnson and Brad Hottenbach presenting on IP protection for digital health innovation. Take it away.
So thanks for having us. Matt and I are both patent attorneys in Dorsey's patent practice, and we're going to we're going to try and introduce you to a little bit to our world and maybe get you to think today about some issues that we find perplexing, and we're not exactly sure where the law is going to go with them. And hopefully it will. It's interesting to us, so hopefully it'll be interesting to you as well. First, we wanted to look at the landscape of digital health technology. From our standpoint, we look at intellectual property and say, what is protectable? What can we help our clients protect and prevent others from using or prevent others from gaining access to? And here's just a laundry list of things that we thought might be interesting. Drug candidate screening, gene variant analysis. We're gonna, with respect to the first one, we've got an example later that we're gonna go into more detail with. In silico testing, Matt is gonna do a deeper dive on the area of diagnostics, which is a really thorny problem in the world of patent protection right now. Monitoring, you guys already had a whole session on monitoring this morning, and there's the technology behind that and various aspects of that that are definitely protectable. Things like predictive analysis, electronic medical records and data management. A lot of talk around there is maybe use of blockchain application on records management, and that's a really interesting area of technology right now. So then the question is, why do you want to protect these things? And then the second question is, how do you protect these things? So we'll talk about the why real quick, and then we'll get into the how, which is the realm that Matt and I operate in on a regular basis. Oops, I need to switch the slide. So one way that we look at working with our clients on IP protection is to look at a strategy. It's a little hard to see up there, but you can look at it as a life cycle where at the top in the white arrow, there's innovation in your company. And then you develop an intellectual property position around that innovation. Maybe you develop a portfolio that has some value that you can then leverage. And then because you've leveraged it, you've generated revenue, and now you've got opportunities to develop new opportunity because of that cash flow coming from the IP that you've developed. Why do we do this? Well, it's potentially going to provide you a competitive advantage in your marketplace. If you are the only one that can do X, you're going to try and protect current and future product developments. If you're really strategic about this, you're going to look at your industry and say, where is the industry going and how can I get in front of that, and how can we develop our technology to get in front of that, and how can we stake out space and put a fence around that. And that's a lot of the thinking that we do. Pay attention to cost. For a lot of companies, especially smaller startup companies, their IP can be a basis for company valuation as part of their exit strategy. So that can be really, really important. If you're a larger company, it can be a basis for an ancillary monetary stream when you're talking about companies like a Microsoft or an HP or an IBM, and even Motorola. I believe I saw a statistic years ago that Motorola was making more revenue on licensing of their technology that was not core technology than they actually were in selling their core technology. So it can be very important for developing an ancillary revenue stream, and we're going to look at that in a second as well. So not knowing where everybody is in terms of this, we thought we'd start at a base level and just look at the types of intellectual property real quick and make sure everybody's on the same page. You can see we've got this Venn diagram indicating that there's a lot of overlap between various types of intellectual property protection. We've got trademarks on the right-hand side, which provide an identification of source for your good or service that you're selling. We have copyrights, which protect original works that, according to the statute, are fixed in a tangible medium of expression. Basically, if it's put down on paper or designed even on a computer, but you can see it, you can get copyright protection for it for the most part. And then we have, in the US at least, two types of patent protection. We have our utility patents at the upper left, which protect structure and functions of devices, systems, chemicals, methods, processes, et cetera. And then there is in the US, it's a design patent. In other jurisdictions, they look at them as design registrations, and they protect aesthetic ornamentation of a utilitarian object. So I've got this clicker in my hand, and there's a bunch of different ways that somebody could make a clicker. It could be boxy, it could be nice and svelte like this one, and you could get a design patent or a design registration on how you've designed this clicker. Finally, at the bottom left, we've got trade secrets, which can, if you keep secret and are able to keep secret, formulas, algorithms, know-how, that can be a competitive advantage with respect to your industry. Just real quick, we thought we'd show you a couple of examples of this overlap that we had in the Venn diagram. So here you've got the Apple iPhone and the slide to unlock option, and Apple received a utility patent on the design of the functionality behind that. And then they also received a design patent on their screen design on how that worked. Here's another quick example of design, trademark, and copyright all in one image. You've got a United States design patent for the interface for Google's home landing page. You can see that Google is a trademarked term identifying the source of search services. And at the bottom, you have a copyright also covering the layout of the Google home screen and how they've set it up. So just a simple example of how you can overlay lots of different IP protection to protect your technology. So with that introduction, I'm going to turn it over to Matt, who's going to do a bit of a deeper dive into the world of patents, which is where he and I play in a lot, and there's a lot of interesting stuff going on right now.
So I'm Matt Johnson. I have a PhD, so it's going to be a little bit more professorial. So I thought I'd start at the very beginning with the Constitution and where do we get these sorts of protections? Oh, I should preface, I'm not a constitutional scholar, I'm a molecular biologist, but it's the same thing, no one ever asks. So these protections really emanate from the Constitution. And what I'm gonna try and show you is how that's recently developed to sort of change the language that was originally in the Constitution and the effect it has on a field that many of you are interested in, diagnostic methods. And you may have heard lately that you can't get a patent application granted on a diagnostic method. For the time being, that's true, but we wouldn't counsel you not to try and go for something like that. So towards the end of my section, I'll give you some hope that things may be changing. But let's take a look at what the framers originally said they wanted to do, and they wanted to give Congress the power to promote progress of science and useful arts. So by giving authors and inventors the right to exclude other people from using their writings and discoveries. So that's pretty broad language. I can discover a lot of, so let's just stick with the inventing because that's what we're going to talk about. I can discover a lot of things, but recently the Supreme Court has put the kibosh on that just a little bit. And I'll get into that a bit in a moment, but I wanted to tell you that there are, from that clause, we've got several hurdles to get through to get a patent issued. So the first one is it's got to be useful. And that comes directly out of the clause that I just showed you. So it's got to be useful, and that's pretty broad. It doesn't limit a lot. It'll limit things that are demonstrably impossible, perpetual motion machines, some illegal objects, but for the most part, lots of inventions have utility. And so most things get past that. The next thing is a patentable subject matter. What is patentable after being useful? And it used to be, at least when I started out, it used to be anything under the sun made by a human being. And what I'll describe to you is that's been pulled back a lot to limit what's going to be patentable. We'll get into that in more depth in the next slides. But then the next two hurdles are novelty, which is essentially no one's had the idea and written about it before you. And for a patent attorney, that means written in a single publication, in a single manuscript, in a single paper, or a patent. And then non-obviousness. That's a little squishier, but essentially what it means is that the examiner can say, well, you're trying to patent A, B, C, and I have a paper that teaches A, B, and A and B, and another paper that teaches B and C. It would have been obvious, common sense, to put those together and come up with your idea. So that's just a brief overview of the basic hurdles. I think the subject matter is what we decided to talk to you about today, because most of you are interested in that. And there's an aspect of that, and that is a lot of the speakers talked today about diagnosing, predicting, and how that's been clawed back and is no longer, at least for the time being, patentable. So I'll show you what the laws say. It's whoever invents or discovers, again, very similar to the language we saw from the Constitution, any new and useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof. And that's a lot of words, and the courts get to interpret those words. And recently, they've pulled back on the discoveries aspect, so that that not all discoveries are going to be patentable. Specifically, a link between a biomarker, DNA or metabolite in the system, and a disease state, right? And that's important to this audience because you want to identify those disease states early so that you can target therapies towards them. Well, the simple act of tying that metabolite to a disease state is no longer in and of itself patentable. And so in these slides, we've given you some direction to some of the current literature on it. Here are, we've given you a link to the 2019 revised patent subject matter eligibility guidance from the Patent Office itself. And what they've told us is that there are certain things that are absolutely not patentable. Abstract ideas, laws of nature, mathematical concepts, some types of organizing human activity, and purely mental processes. So where do diagnostic methods come down? Well, they're almost laws of nature, right? I mean, that's what we're trying to do is correlate this this change or this metabolite or the presence of a mutation with a disease state. And it's also sort of mental process, right? It's something that the clinician will do, or maybe now an app or AI will do, and link those two to send a patient down a treatment pathway. So you can also think that a lot of things that you try to patent rely on these things that the Patent Office and the Supreme Court has said are not patentable. So how do you tease those two apart, right? I mean, almost everything that's invented relies somehow on a mathematical concept or a law of nature, right? You can patent a plane, and a plane relies on gravity and defying gravity and Bernoulli's equation, but it's not simply directed to those things. And so what the Patent Office has directed their examiners to say is to look at what someone is claiming in the whole, and ask whether that which they're claiming is solely one of those exceptions, or are there other things integrated into it or integrated with it that lift it out of this exception. And so the language is the examiner is directed to determine whether judicial exception is integrated into a practical application. Again, sort of squishy language. What does that mean? And so to sort of tease this out, I think we're going to go through an exercise that the Patent Office has given us and directed specifically to diagnostic methods. And so the next slide is some of the more recent guidance that has come out on how to discern the difference between things that are accepted and things that are accepted. So there's two guidance memos from the Patent Office issued in the last couple years, and they deal with how to make a diagnostic method patentable, how to lift it out of this realm where it's an exception to the patentability rules and get some protection for the inventors. And one way is to do to link that diagnostic method. So link that diagnostic method with the next step, which is a treatment, right? So it changes it from a method of diagnosing a disease state based on a biomarker to going a little bit beyond and proposing a treatment method. So it requires another step in your knowledge of what that biomarker is and what it's linked to, and proposing how we would treat someone that either presents or doesn't present with that marker or that mutation. And some of the case law has said that method of treatment doesn't have to be specific. It doesn't have to have dosages and timelines. It can be something almost as nebulous as treating someone with an effective dose. So that alone will, although what you're trying to protect really is the method of diagnosing, if you combine it with a step of treating, or in some cases not treating, you can make that diagnostic method into a patentable claim. So the other way to do that is something that's probably a little bit obvious, is have a new diagnostic device, a new diagnostic methodology, not simply tying the biomarker with the disease state, but there's something in between. It's how do you, a novel way of measuring that biomarker, a novel way of isolating that biomarker, and then you create patentable subject matter. So again, it's not simply a diagnostic method, but it's a little bit more than that. It's a novel method of measuring, or a novel device that measures. So we'll go now into a specific example that the Patent Office has given us about how to make a diagnostic method that will pass muster as far as patentable subject matter. And so what the fact pattern that they provide is that the inventors have discovered that there is a correlation, that there's a disease called gelitis that they've made up. It presents as a rash, and that rash is tied to the presence of a protein in the skin called JUL1, again, fictitious. And that previous methods of treating this disease were ineffective, but it may be that you can give an anti-tumor necrosis factor antibody to patients, and in some cases they will be cured. But these inventors have come up with the correlation of the JUL1 protein. They've got an antibody for that JUL1 protein that they can use in a diagnostic method. And they've got a treatment, which is the anti-TNF. So some of those are seemingly new. Some of those appear to be old. And how do you go about and create claims that the examiner won't dismiss immediately? And so I'll show you some of the first claims. Now, we're gonna tease this out a little bit more, but just because it's patentable subject matter doesn't mean that it's allowable. They're just trying to illustrate to practitioners and inventors what is possible if you have a diagnostic method. They're not saying that they're going to give you or issue a patent claim, but they're telling you to go down this road. And these are the two sort of broadest claims that they give as examples. And the first one is a method of that are going to be eligible. So the first one is a method of detecting, and that sounds sort of like diagnosing, but as you'll see, it's the second idea is that you're not simply correlating, but you've got new ways to identify a disease state. So this is a method of detecting JOL1 in a patient. The steps comprising obtaining plasma from a human patient, that's pretty routine, and then detecting whether JOL1 is present in the plasma. What here they're calling out this JOL1 antibody. It turns out in their fact pattern that most patients present with some JOL1 reactive antibodies. So although that isn't completely new because your bodies were doing it, they're not going to dismiss this as non-patentable subject matter because there's more than just method of diagnosing. There's more than just diagnosing and correlating a disease state with this biomarker. There are specific steps. And then the last claim, number 7, is the method of treating. So they've added that second step. They've added the step of identifying a patient with gelitis and then treating that patient. So again, these are eligible for patenting, but that doesn't mean that they're going to be allowed. And in fact, most of what they're claiming here is routine and conventional, at least in the eyes of the fact pattern and what they would call the prior art. So although these are going to get through that second step, okay, they have utility, and they are not within the exceptions, laws of nature, mental processes, mathematical formulas. They're going to get tripped up by the last two hurdles, the novelty and the non-obviousness. We won't go into that, but you can see in the fact pattern that I told you about, it was pretty routine to treat these patients with TNF antibodies and detecting and obtaining plasma samples from patients. Those were pretty routine, but it got through the first two hurdles, which isn't bad. And for the present state of affairs, at least in diagnostic methods, that's good because we as patent practitioners have more arguments when we get to the last two hurdles. But sometimes the fight is just getting to those hurdles before they kick us out. So here's another claim, and it looks very much like the first two, but here it's pretty obvious. They put up the red flag, and they've called it a method of diagnosing. And so although it looks very similar to what I showed you before, in the last step, this step C, they're simply diagnosing the patient with gelitis when the presence of JOL1 is in the plasma. And so that's exactly what I told you would not be eligible, because you're just taking a natural state that's a correlation that's been happening even before the inventors discovered it, and the Supreme Court has said that this is something that's already taking place. This method of diagnosing is simply a mental process, defining a law of nature. And so they're not going to allow this. And this is going to get kicked out at the second hurdle. And you're not even going to be able to get to the novelty and non-obviousness hurdles. So what about getting over the last two hurdles? And that's where we come to the third sort of class of claims, and that is how can we as inventors or as patent practitioners wrap in a little bit of the extra stuff so that the mental process or the law of nature is sort of integrated into something is integrated into something more. And as I told you, there are ways of making the device or method of detecting novel and new. And here, what the fact pattern has told us is that these inventors have used a pig antibody for Joel. And that hasn't been used before, at least under this fact pattern for medical treatments. And so that simple statement of making that anti-Joel antibody a pig antibody is now bringing it out of a simple method of diagnosing. The caveat is that if you develop an antibody in another organism, or you make it in vitro, this claim isn't going to cover it, right? And so if your competitor goes ahead and makes a different type of antibody in either a different organism or through in vitro methods, they will get around this patent claim. And so you've gotten a patent claim here, but it's very narrow. It's narrowly tied to this pig antibody or whatever the device is that you're using to measure your biomarker. So 4 is even more, claim 4 is even more specific. It's not just a pig antibody, it's this specific pig antibody, MMAB D33. So monoclonal antibody D33 is something that they developed in their labs. No one else has it. It's not found in nature, although it recognizes the Joel-1 protein. They did it through monoclonal hybridization, and it's brand new because it's got little bits of different things in it. And so that again is going to be both patentable subject matter and allowable, but again, it's going to be very narrowly directed towards your specific monoclonal antibody. So the last two are method of treatment claims. They include the diagnosing step, but they add this something more to pull it out of the exceptions. So what do we tell our clients that want to patent a diagnostic method? Given that I'm a lawyer and I'm a patent lawyer and it's my job to try and get patents allowed for clients, you might imagine that I say go ahead and file an application and try and get a claim issued. But I don't just say that out of hand. I actually convinced my sister, who's an academic oncologist, to file patent protection for her diagnostic method, which identifies patients in a population of breast cancer survivors that will react better to one treatment over another. So I had to tell her at the beginning that her method alone was probably not patentable under the current state of the laws, but the hope was that would change because it's still patentable outside of the United States, and there's a strong industry directed to diagnostic methods that will hopefully change the laws. And so that's in fact happening. So again, you saw that this guidance is coming out of the patent office, giving patent practitioners more ways to try and protect diagnostic methods. And currently, there is legislation sort of percolating through both houses of Congress, and it has a good chance of surviving, mostly because none of you know about it. So it's not a wedge issue, and both houses are interested in doing it. Both sides of the aisle are interested in doing it. So it may just happen, and it's not really all that fantastical a change. It's simply going back to the original wording, right? Where it's discoveries. It's not just inventions, but it's discovering something new or it's discovering something useful. So here's sort of the language that the drafters have put in to underpin the new wording, which is sort of shockingly similar to the existing wording. And so I'll read that existing, or I'll read what they've sort of drafted for the new 101. And you'll have to go back to thinking what the original slide said, but it's whoever invents or discovers any useful process, machine, manufacture, or composition of matter, or any useful improvement thereof may obtain a patent. So it's not all that different from what I read you at the beginning. The one sort of obvious change is new. They've sort of taken new out. But new shouldn't be in there, right? Because new is going to be encompassed by those second two hurdles, the novelty and non-obviousness. And this is just deciding what gets in to be scrutinized by those other two rules. And so, in fact, what they've done is say, no, we don't do this integration thing, and we don't do these non-conventional analyses. Those are for the second steps. And so the patentable subject matter is hopefully going to be simply discovering, right? So I can discover a diagnostic method. I can discover a correlation between this biomarker and this disease state, right? That will inform methods of treating, but I don't have to link it to that, right? I've discovered something new. It wasn't known before. It has value, right? It has utility. It has value. And a lot of the things that we've talked about today are, predicting and diagnosing, right? How do we identify this patient population before it gets really expensive, right? And get in there and treat that patient population to prevent, a cascade of costs down the road. So hopefully this will happen soon. Nothing really ever happens soon, but there is hope on the way. So if you or your inventors are sitting on top of diagnostic methods, and in fact, I'm sure that people are, right? I know for a fact that people are, because clients will tell me, we've got these genetic markers, and they're better than the ones that are on the market right now, but we can't divulge them because we can't protect them. And if we can't protect them, we're not going to be able to commercialize it, and our board is going to freak out because we've given away lots of value. And so my recommendation to them is, yes, it's not patentable right now, but it should be in the future. And so if you get it on the books, and just there are ways to sort of slow down prosecution and hope for changes in the patent office. And then hopefully after these laws go into effect, you can go ahead and patent the method of diagnosing or method of predicting. So that's my last slide. And then Brad's going to follow up with more talk on some of the other subjects, specifically trade secrets.
So I'm going to go in a little bit different direction. Still going to talk about the patent statutes, but it's going to tie a little bit more into data and AI and where that is potentially taking the patent law. So what can you use big data for is the first question. And Matt's talked about diagnosis and, for example, risk factors. If you were, you could find out, for example, if you have the BRCA gene and are at a higher risk of cancer. If you can use big data for help in determining outcomes, for help in developing or looking at the outcomes of clinical trials to figure out with more granular detail what might be the cause of something going well or going wrong. Data manipulation in this respect is going to be is already a big component, is going to be even more of a big component as we move forward with the health industry. Something that I was just noodling on when I was thinking about big data was, and I think it's one of the earlier sessions was talking about reimbursement and coding. Can big data help you improve reimbursement revenue? Can you use artificial intelligence, software and algorithms to mine huge data sets? Maybe as part of that, correlate the treatments, diagnoses, health, lifestyles, et cetera, to figure out what is reaching the better outcomes, what is resulting in lesser outcomes, and if your reimbursement model is based upon something beyond fee-for-service but outcome-based, then that data can be very important and significant. Other uses of data, as an alternative revenue source. This is the Google and Facebook model. How do we leverage this data that we already, that we're collecting on all of our users and monetize it? Now, in this industry, there's a separate question of HIPAA rules that, don't allow for the identification of personal information. And so you've got to be much more careful in terms of doing this. So the question is, it comes down to, in large respect, how do we protect it? Can we keep it a trade secret? Is it something, though, that maybe somebody else, if just looking at what we're doing, can figure out how we're doing it? Then maybe we want to look at patent protection to try and prevent them from reverse engineering or doing the same thing we are doing here. And so when you're talking about big data, a lot of the time you're talking about using artificial intelligence, neural networks, et cetera, to manipulate that data. And so I wanted to look at the effect of the patent statute on some of these uses of artificial intelligence and whether or not you can get protection for these kinds of inventions, if you will, if you are developing some really interesting new technology to help you. We talked about, or Matt was talking a lot about the subject matter eligibility of Section 101 of the patent statute. Whoever invents or discovers may obtain a patent therefore. And the prior section in Section 100 defines what inventor is, which is the individual or individuals who invented or discovered the subject matter. And this, when you're talking about artificial intelligence, begs the question, what level of human involvement might you need in order to be able to apply for a patent and actually receive patent protection? What is necessary for inventorship to arise? And I was thinking about this. You guys may recall a couple of years ago there was the whole hubbub about the photographer that got the macaque monkeys to take pictures of themselves, selfies, and then it went viral, and he was upset that people were making money over these photographs that he thought were rightly his, but that the monkeys took, and it actually wound through court. And on the copyright side of things, at least the U.S. courts made a determination that a monkey is not a human being and therefore can't be an author, and therefore there is no copyright protection under the U.S. copyright statute. And so we've got a similar situation here. Is anybody familiar with the infinite monkey theorem? Has anybody ever heard of that? So the infinite monkey theorem was proposed by, I can't remember the gentleman's name, but the idea was that if you took 1 million monkeys and you sat them down at typewriters and you had them go for years and just type and type and type and type, that likely one of them will type a Shakespeare sonnet word for word, and so there is some creative is there creative originality? Is that a work of authorship? If Shakespeare wrote it, we would recognize it as a work of authorship. But if a monkey is sitting at a typewriter and just randomly pecking away, do we consider that a work of authorship that would be subject to intellectual property protection? And that's kind of where we are with AI right now and the idea of inventorship. If a machine is churning through and performing these functions and spitting something out at the end that happens to be a new discovery, is it patentable? It's interesting, I didn't put this up, but Matt was talking about the other two tests for patentability are novelty and non-obviousness, and those are in section 102 and section 103 of the patent statute. And if you look at section 103, in addition to saying that an invention can't be obvious, it goes on to say that patentability shall not be negated by the manner in which the invention was made. Well, how far does that extend? Does that extend to invention made by a neural network or a computer, the IBM Watson sitting there chugging away? Is that what they had in mind when they wrote the statute? If you look at a lot of drug candidate testing, a lot of it is trial and error. You look at a candidate, you try and determine whether or not it's having the intended effect or not. Does it have any side effects, et cetera? And a lot of that is, and all of that right now is trial and error. But what happens when you let a computer model do that rapidly and churn through millions and millions of possible permutations and combinations, and it comes out with say 10 candidates that are potentially more viable than anything you've ever done. Does it matter whether a human being seeds that AI program with potential direction toward a therapy? What particular configuration, what level of human involvement is required for that machine or for a human to be considered an inventor and have involvement? And then the question becomes, what is the invention? Is it the algorithm that the human programmed? Is it the output of the computer system? Did you have to create a special purpose machine to do this? Is that the invention? These are all questions that we really, in our world, don't have the answers to yet as we're moving forward in the realm of AI. I wanted to read. Well, let me switch to the next topic. So in addition to this idea of inventorship, we also again talked about the steps for patentability, and one of them again is whether the invention is obvious. In a recent case that was actually a Supreme Court case, Justice Kennedy said in remarking on the test for obviousness, a person of ordinary skill, which is what is considered in the test for obviousness. It's not a person of extraordinary skill, and it's not a person that doesn't know anything about the subject matter you're talking about, but it's somebody that works in the field, basically, and that's the level of person that you would consider when you're talking about obviousness to determine, would that person have put 2 and 2 together? As Matt said, A and B plus B and C, would they have thought to put those together and create the invention? Kennedy said, this person is also a person of ordinary creativity, not an automaton. And yet, here we go, we're circling back to, we're using these computers to do all this work, process all this data, come up with an output. Where does that leave the automaton in the process? Then you come to the question of, well, if somebody is of ordinary skill and they're working in this field all the time, aren't they going to be expected to stop doing manual trial by error and start using these computer tools that are made for them? I mean, that would be the level of ordinary skill at some point. We've now raised the bar that the level of ordinary skill is you're going to use these AI tools to test your drug candidates or do whatever you are doing with the data that you're manipulating. Maybe you've got a large data set and you're trying to find new gene markers or other biomarkers, or you're trying to, you've got a large set of CT data and you're trying to use that to diagnose brain conditions and other neuropathies or whatever. Is that part of their skill set? Okay, so then if you use an AI tool in developing your invention, does that make it obvious? Because it would be obvious for anybody to use an AI tool to develop the invention. And so now, is it just a discovery that anybody should have known? And so it gets back to Matt's point. At this point, a lot of discoveries are not considered patentable, even though it says it in the Constitution and the patent statute. Just really interesting issues that we're going to have to grapple with in our world in the short term. I'm going to read you this slide is some bullet points that are specific to this article by Segler that's linked at the bottom. And I actually do want to go back. There was on one of the slides, I can't remember which one it was. I just want to point out, I'm going to go back real quick. This article about the infinite monkey theorem, you see at the front, it says Ben Hottenbach. That's A, not me, and B, no relation to me. Although I have talked to Ben before, but a very diverse branch of the family way back. But I just wanted to make sure I was clear that that wasn't me that wrote that article. Anyway, I want to read you the abstract of the paper that promulgated these bullet points here. And this is about planned chemical synthesis of drugs. And the authors write, for medicines to materials, small organic molecules are indispensable for human well-being. To plan their syntheses, chemists employ a problem-solving technique called retrosynthesis. In retrosynthesis, large molecules are recursively transformed into increasingly simpler precursor compounds until a set of readily available starting materials is obtained. Computer-aided retrosynthesis would be a highly valuable tool. However, past approaches were slow and provided results unsatisfactory in quality. Here we employ a Monte Carlo tree search in order to efficiently discover retrosynthetic roots. The Monte Carlo tree search was combined with an expansion policy network that guides the search, blah, 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 blah. These deep neural networks were trained on 12 million reactions, which represents essentially all reactions ever published in organic chemistry. Our system solves almost twice as many molecules and is 30 times faster in comparison to the traditional search method based on extracted rules and hand-coded heuristics. Finally, after a 60-year history of computer-aided synthetic planning, chemists can no longer distinguish between roots generated by a computer and real roots taken from scientific literature. We anticipate that our method will accelerate drug and material discovery by assisting chemists to plan better syntheses faster and by enabling fully automated robot synthesis. That was written in 2017. Pretty amazing. We're 2 years beyond that. It's just going to keep getting bigger and bigger. And so you've got, drug companies out there, all kinds of other health companies out there that are manipulating data. They're whatever that data might be. And if you come to a point that says, well, if you use computer-aided tools to do this, and the computers are just really running on your own, there's no IP protection for you. So then where are you in the marketplace? All of your competitors can move into the realm that you're in. And what is then the incentive for companies to move forward? Because ultimately you've got to make money doing this, right? And if you're in a position where you can't achieve any sort of IP protection around it, what's the incentive to progress your art or your science? And that's a really fundamental question that we're going to have to deal with in our space in the coming years. And hopefully the right decisions are made, because that could be a real down moment for the industry. Just a final quote from Justice Kennedy in that same case. We build and create by bringing to the tangible and palpable reality around us new works based on instinct, simple logic, ordinary inferences, extraordinary ideas, and sometimes even genius. These advances, once part of our shared knowledge, define a new threshold from which innovation starts once more. So we've raised the bar. He's saying we've raised the bar on what is obvious and what should be known. And as progress from the beginning from higher levels of achievement is expected in the normal course, the results of ordinary innovation are not the subject of exclusive rights under the patent law. Word otherwise, patents might stifle rather than promote the progress of useful arts and sciences. The problem is if you take that too far, you've completely stifled everything. So just a fun thought to leave you guys with. But those are the interesting sort of mental gymnastics that we're grappling with in our world. And thanks for letting us share them with you.